Good day, Crime Talk aficionados. We have a great show for you today. First, the feds want the appeal of Alex Murdaugh dismissed. The argument was held today on the Karen Reed trial and whether charges should be dismissed. Sarah Boone wins a victory in court. A teacher saves a young woman while being attacked. And what the hell is going on in New York City? And then finally, our dumb criminal of the day. And I'll give you a hint. It doesn't involve food crime. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. All right, let's go ahead and get to the docket today for August 9th, 2024. And first on the docket, Alex Murdaugh. Just when you thought Alex Murdaugh was gone to prison and we're never going to hear from him again, wait, there's more. Well, he is obviously serving his multiple life sentence in state court for the murders of his wife, Maggie, and son, Paul. He's got the separate theft cases that he pled guilty to, and then he had the federal cases as well where he got a lengthy sentence. Well, he appealed the sentence in federal court. And the prosecutors in that federal case are saying you need to dismiss his appeal. And the reason you need to dismiss his appeal is that there was a waiver of his appellate rights. All right. So Murdaugh's appellate waiver bars the Eighth Amendment claims raised in his opening brief, the government is saying, and he waived his right to contest either the conviction or the sentence in any direct appeal, according to the government. Now, Murdaugh's appeal does not fall under the provisions of ineffective assistance of counsel, prosecutorial misconduct, or future changes in the law. The only options the former attorney had to seek for an appeal in the federal system. So when you plead guilty in the federal system, and it never used to be this way, I'd say maybe until 5 years ago, it really caught on everywhere, that if you plead guilty, there is an appellate waiver, which means you're not going to appeal because you don't like the sentence, you think it was too harsh. The only time you can do that is basically your counsel was ineffective. Well, when you plead guilty, the judge says, are you happy with the representation of the attorney? The defendant says yes. If the defendant says no, there's no plea. And the only time I've really seen this be an issue is when there was an attorney who wasn't an attorney because he didn't have a license and he was practicing law in federal court. Clearly, that person could appeal and get a new counsel because he's entitled to effective assistance of counsel, who's really an attorney. The other provision would be is if there turned out to be that there was some sort of prosecutorial misconduct or a future change in the law where they said, hey, whatever you're found guilty of, we're going to reduce those penalties so much, or we're just going to make it not criminal to do what you did. So very rare under those circumstances. And they do that because the United States attorney wants finality. If somebody pleads guilty, that's it. You may not like the sentence, but you know that's what you're going to get. And that's what happened here with Murdaugh. Now, Alex Murdaugh pled guilty to 22 federal financial crimes back in April of this year, and he was sentenced to 40 years by the district court judge. And Murdaugh's intent to appeal came just 2 weeks after he was sentenced. The argument that the defense team argued was that the 40-year sentence is a de facto life sentence for the 55-year-old attorney who's also currently serving those 2 life sentences for the murders of his wife, Maggie and Paul, like we mentioned. Now, on the appeal, Murdaugh's lawyers argued that even if Murdaugh served 85% of his sentence, he would still be required to serve 34 years, which he should have known that going in. And they said that Murdaugh's life expectancy is only about 24 more years, given the Social Security life expectancy tables. You could probably reduce that by a few years while you're in custody because you're not exactly getting the best care out there. Anyway, the pleading state the guidelines for the sentence should have landed Alex Murdaugh anywhere between 17 and 22 years. And they cited other cases of similar circumstances where basically the average sentence was 17 and a half years. Now, both the defense and the prosecution originally requested the judge to impose a 30-year sentence, but the judge said that the sentence for Murdaugh had to be harsher punishment than suggested because he stole from the most needy, vulnerable people like his clients who became a quadriplegic after a car crash, a state trooper who was injured on the job, and a trust fund meant for children whose parents were killed in the wreck. Now, Murdaugh attorneys say, hey, that sentence is a backstop to make sure that he served time for the murders, because they anticipate that he is going to be getting a new trial in his state case. Let me tell you, ladies and gentlemen, when you plead guilty in federal court, you go in on what they refer to as an open sentence. The guidelines are one factor, just one factor that the court needs to consider, and it's a starting point. And even though the other guidelines, said, okay, 17 to 20 years or 30 years, whatever the prosecution and the defense are asking, that's just a recommendation. A federal judge is not bound by that. In fact, the judge could have imposed the maximum sentence possible for not only Mr. Murdaugh, but for any sentence, obviously, if it's justified under the record. This case, it was. And there was an appellate waiver. And just because you don't like the sentence doesn't mean that you get to appeal it and say, I want to do over again. That's what happens when you plead guilty in federal court. Anyway, the defense is asking the court to send this case back to the district court for resentencing with a new judge from outside the district. That's not happening. I think the appeal is probably going to get dismissed because of the appellate waiver. I've seen people in other cases in jurisdictions which I have practiced where they file an appeal and the prosecution cites there's an appellate waiver and the appellate courts kick it back. All right, the Karen Reed case. That's right. There was a hearing this afternoon. We brought it to you. Obviously, what the defense attorneys are doing for Karen Reed is try to have at least 2 charges dropped in her murder case, which is obviously scheduled in Massachusetts, not only for this motion, but for trial after the first of the year. Now, as you may recall, her first trial on the 3 charges began in April. Count 1 was to the charge of second-degree murder. Count 2 was the charge of manslaughter. And count 3 was a charge of leaving the scene of an accident with injury or death. Now, the prosecutors had a couple of difficulties during their presentations of the case to the jury as it relates to Karen Reed, including some surveillance video from a police garage that appeared to be inverted and some embarrassing text messages about some very regrettable text messages sent by the Massachusetts State Police trooper assigned to investigate the case. That trooper was later suspended, and others have faced internal affairs investigations as a result of that. Now, Karen Reed's first trial ended in a mistrial on July 1 after the jury of 6 women and 6 men repeatedly informed the judge that they were hopelessly deadlocked. Subsequently, both the defense and the prosecution informed the court that some jury members came forward to report that the panel was in agreement that Reed was not guilty of 2 of the 3 charges. Now, I personally don't think the judge is going to reconvene the jury to question them about this issue. Basically, the defense is saying they're saying because they have information from jurors, they believe the judge can enter a verdict of not guilty on these charges. And obviously that's what was argued today. Now, the prosecution has some precedent, says you can't do this. I don't think, I'm going to have to agree with the prosecution, okay? And I'm no fan of the prosecution, okay? But I just think the judge, everybody got it wrong in this particular case, and that's just what happens. So the judge took the matter under advisement. No real idea when the judge will issue an order. But if we're taking bets, I'm going to say denied. Anyway, the prosecutors have said that they will retry the case, and the new trial is scheduled to begin on January 27th of 2025. Next on the docket, Sarah Boone gets a victory. That's right. Today, Ms. Boone appeared back in court again and argued her motion that she be unshackled in court, specifically to the judge that she wanted to have her hands free during the pretrial hearings, but wanted to be fully unrestrained during the trial. Now, the sheriff deputies that are dealing with Ms. Boone testified at the hearing saying that he did not believe that Ms. Boone should be unshackled. The testimony came out as follows. Based on her current charge of second-degree murder, she also has previous domestic arrests for battery, strangulation. She has 3 separate incidents at the jail for non-compliance when she was told to attend her court hearings, her scheduled court hearings, and she refused to do so, even though the corrections officers told her that she could be charged with contempt of court. She still refused to attend those hearings. When you combine all that, it shows a propensity for violence and not wanting to follow the lawful commands and orders from law enforcement personnel. I'm just asking to sit here unhandcuffed so I can write without taking skin off my hand and being extremely uncomfortable, she told the judge. Now, the judge ruled that Ms. Boone will not be handcuffed for future pretrial hearings, but will be in a leg shackle, and for trial, she will have neither shackles nor handcuffed, but she's going to be fitted with a stun cuff. That's right. The deputies explained what that is, that it is a wireless electronic cuff, and it's secured around the defendant's leg and can discharge 50,000 volts of electricity, causing the person to fall instantaneously like a sack of potatoes. Well, the sheriff didn't testify to that. I just threw that in. Anyway, a deputy will be in the room and monitoring the cuff. Now, Ms. Boone is due back in court for another hearing on August 14th, where the two sides are expected to discuss how Ms. Boone can have access to her case discovery. These little shackles, had a client once. He was accused of attacking a judge and some deputies. Nice guy, for the most part, other than, some aggression issues. Anyway, he was, not only did he have handcuffs attached to a belly chain and his legs were shackled when he came to court, he got a stun gun strapped to his belt. It was a stun belt. And they did maybe say that they had to do it on his way back. I didn't see it, but apparently he dropped quite quickly for not behaving for the rules. Now, that client ultimately got shot and bled out, so he didn't get his day in court. But, hey, those kinds of things happen. Now, Ms. Boone, she's clearly got a record of, misbehaving, and maybe can be a little aggressive. Maybe she'll be a little aggressive if she has her hands free. Maybe she'll take a dash for it. Who knows? Hey, it's not like she's going to be zipping the deputies up in the suitcase and, playing games with them or anything like that. So let's give it a shot. Let's see where it goes. I've also seen defendants literally shackled to a chain to their leg that goes to a hook on the floor so that they cannot run away. Judges don't like that because it makes it difficult for the defendant to stand up when the juries come in and out. Next, a teacher saves a young girl from a sexual assault. That's right, a middle school teacher from Texas is being hailed as a hero after he grabbed his gun and saved a 15-year-old girl who was being attacked outside of his home. So the assailant follows the teen into a gated apartment complex after she got off a bus on the Houston's east side around 12:30 a.m. on July 28th. This is all according to the sheriff's department. That's when the teacher, the Good Samaritan, David Garza, heard this girl screaming for help outside his apartment. Garza looked out the window and saw a man beating up on the young girl while she was on the ground, trying to take her clothes off. Garza immediately grabbed his gun and ran outside to confront the attacker, and he said that the suspect had the girl by her hair. Now, he ran outside, asked what's going on. The girl screamed, "I'm 15, help me." Mr. Garza then pointed the gun at the guy and told her to get off of her. Garza holding the handgun on his front porch, still shirtless and screaming, "Get away from her." Anyway, a neighbor believes that Mr. Garza saved the young girl from a potential tragedy. I agree. Police are seeking any information about the suspect, who was wearing a black hoodie with a white Reebok logo, blue jeans, and white tennis shoes at the time of the attack. Mr. Garza, you are our hero of the day. See, good guy with a gun stops bad dude from doing bad things. It works that way. Next on the docket. What the hell's going on in New York? It seems like they're a little out of control. So a repeat offender on probation, allegedly, punched a New York Police Department police officer so hard that she fell to the ground before other cops pounced on the violent suspect on a Bronx sidewalk. Meet Ernst Delma. He slugged the female police officer in the face when she tried to break up an argument between him and a group of kids about 7:10 in the evening on the corner of Rosedale and Randall Avenues there in New York City. The video captured by a bystander shows the officer's partner rush the suspect while other cops and witnesses check on the police officer who's still on the ground with a bloody face. Now, when the assaulted cop gets to her feet, her partner lands at least 2 haymakers on the suspect during the struggle on the ground, and as the alleged perp resists arrest, his pants and underwear fall down before he is ultimately handcuffed with his naked behind showing as spectators look on. Now, the injured officer sustained a cut to her lip and taken to a local hospital. Delma faces charges of assault on a police officer, resisting arrest, and obstruction of government administration. Now, shockingly, Mr. Delma, who's on probation, has numerous prior arrests for assault. Are you trying to tell me that past performance is indicative of future results, ladies and gentlemen? Oh my goodness. On probation for assaults and burglary over the past couple of years, and he was on probation for one case in 2022 in which he randomly slugged a woman who was simply walking along Broadway in Midtown and punched her. Now, just last week, 2 NYPD police officers were shot and wounded as they attempted to arrest a suspect in a Lower Manhattan incident as well. Plus all the other stuff. We literally could bring you a show just about what the hell is going on in New York City. I don't know. Maybe you guys need to bring back real bail instead of the cashless bail. Maybe you need to get a prosecutor actually going to prosecute. And maybe people being a little less apologetic to people that repeatedly commit crime. You get more of what you tolerate, ladies and gentlemen. You tolerate it. You think it's no big deal. You get more of it. You say, we're not going to have this nonsense here. You start locking people up in jail. You're going to see the crime rates go way down because you're going to keep the bad dudes off the street. And we've talked about this before. Crime creates poverty because nobody's going to go where it is not safe. Businesses aren't going to stay in businesses where it's not safe. And next thing you know, the community is going to say, gee, where is my Walmart? I can't buy groceries here. Now I have to go across town. There's no job nearby because the people allowed the crime to take place, they tolerated it, and that is the result that they're going to get. And finally, our dumb criminal of the day. Please meet Paul Aden. He's accused of booby-trapping bathrooms in local businesses in Texas and causing explosions. Now, several people reported minor injuries when the device attached to toilets detonated. Now, the first attack reportedly took place on July 20th, and the arrest affidavit says a man was caught on their security cameras going into the unisex bathroom, and then moments later, when someone else used the facilities, there was a small explosion. Now, detectives say a woman was injured, but she left the location before the report was made. Then just 6 days later, there were 2 more victims in the wash tub in San Antonio. The affidavit for arrest warrant says that an employee was injured when she sat down on the toilet, and moments later, a little girl had a similar experience. The detectives claim that physical evidence left behind at both scenes is the same, and they found the remains from small, readily available commercial fireworks that are designed to explode when pressure is applied. In every case, the affidavit claims that Mr. Aden can be seen on security cameras entering and then leaving the bathroom, sitting in the lobby, watching the bathroom door, and then leaving the area after the explosion. Employees told police they were able to identify Mr. Aden because he is a regular customer who used membership cards, and they have video of his vehicle and license plate. Now, Mr. Aden is facing a charge of arson causing reckless damage and bodily injury. His bond was set at $50,000. And he was in and out of jail the same day that he was, in fact, arrested. Mr. Aden, what the hell are you doing? What a wackadoo, all right? Setting off explosions, so when people sit on the toilet seat, it explodes, and then you watch to see what happens? Mr. Aden, I don't know. That's like just weird. You may want to get yourself checked out because you got some things going on. Anyway, you're a dumb criminal of the day, sir. Congratulations. All right, that's all we have for you today, ladies and gentlemen. Enjoy your weekend. Have a wonderful day. We'll see you next time on Crime Talk. And yes, always remember and never forget, the Constitution matters.